Online, Facebook welcome. Welcome to everyone here in the Zoom room as well. My name is Jennifer Thompson, and I am the Executive Director of NASW New Jersey and Delaware, and I am so excited to bring this conversation to you all today. Before we get started, I want to jump into a little bit of housekeeping items, just so you know the flow of today's event. We are so fortunate to be joined by Teresa Lyons, and I'll share with you a little bit about her background. But she and I are going to have a conversation, but we really want this to be a conversation with you as well. So we're going to ask if you have questions or want to jump in or comment. There are a couple of ways that you can do so. You can raise your virtual Zoom hand if you know how to do that. If you're not sure how to use that, there's a chat box on the side. Throw your questions in the chat box and I will read through them and pop in throughout the conversation to ask them on your behalf. I might call on you if you've got a question so we can bring you on the line as well. And if you don't want to engage in any of those ways, if you want to shoot me a private message in the chat box, I'll be happy to jump in and ask the question on your behalf as well. So lots of ways that we can engage in today's conversation, and you can ask questions and pick the brains of Terry Lyons. So today's conversation is of just such an important one for us to have, and for me personally, this felt really important. The conversation about Justice Ruth Bader Ginsburg and her legacy is one of personal importance, and we'll talk about that a little bit more. But I was so very fortunate to be mentored by one of her mentees over the years, and really had an opportunity to work on issues that were near and dear to the justice's heart, and to continue on with the legacy of leadership and female leadership. So I'm excited to talk to you a little bit about that and what it means for so many of our lives and how we can continue the work. Leading today's conversation is Terry Lyons, and Terry is not just the managing partner of a statewide law firm, Lyons and Associates. Many of you know the firm, but she also holds a master's degree in social work. Best of both worlds. She is also a best-selling author of the book Sticks and Stones, Life Lessons from a Lawyer, and a former state Supreme Court clerk. She is a foster and adoptive parent to New Jersey's abused and neglected youth. And Terry's perspective is intellectually insightful and emotionally compelling. I know you all find that to be true. In many of the conversations we've had, she's been able to join us in many of our workshops. Terry is a trailblazer as well. I think we all know that. Launching the first of its kind, a free divorce app for the smartphone, prosecuting appellate cases that impact millions of citizens, and authoring and overseeing numerous publications with widespread reach. She has been featured in over 250 news outlets across the nation and the planet, and really is a friend of NASW New Jersey. She also sits on our committee and lends her thoughts and expertise in so many ways. In addition to all of that, she is also a phenomenal advocate for women and all things children related. And we are just so grateful that you're here today to lead this conversation with us and share with us your knowledge about the legacy of Ruth Bader Ginsburg and what that means, and answer questions for all of us. So thank you, Terry, for joining us in today's conversation.
You're welcome, Jennifer. Thank you very much. Thank you to all my social worker friends out there, all my lawyer friends out there, and all the people who are neither. You're still my friends. The way we're going to do this, I think, is to do a little slideshow first. Jennifer, with your permission, I'm going to give some background on some things. This will probably take about 20 minutes or so. And then at that point, we will field questions, and I'm happy to answer any and all questions that I can. That's a picture of me. You can see the first thing I want to lead with, and people should be aware that this conversation is going to try to stimulate our brains, but we're also going to have a little levity. And in that regard, the first thing I want to start with, believe it or not, is a picture. Let's see. How do I get to my next slide, Jen? I press, here we go. Everyone, these are my cufflinks that I'm wearing today. The Ruth Bader Ginsburg cufflinks. You can see here they are for people that need to see them. And there actually is a reason why I'm sharing that piece of information with you. Ruth Bader Ginsburg is like Mike. The reason, and I'm going to explain how. So if people think about Michael Jordan, the reality is that there were many basketball players who came before Michael Jordan who probably were better, had a larger impact on the game. Wilt Chamberlain is one of them. But the reality is that at some point in Michael Jordan's career, Michael Jordan, the brand, the icon, transcended Michael Jordan, the basketball player. If you go to any playground across the United States today, you'll see a number of 5 and 10-year-olds wearing sneakers with the Air Jordan logo. And you walk up to those kids and you say, oh, you know, tell me about Michael Jordan. How many championships did he win? Who did he even play for? And they're not going to know, but they're going to know the icon, the imagery, the brand of Michael Jordan. And the reality is that Ruth, RBG, became the first Supreme Court justice, frankly, in the history of this nation, who herself became an icon and a brand, separate and apart from her being a justice. So I'll just give you an example here. If I can, let's see. These are just some of the ways, and think about this. You see on the left here, you see RBG in a Saturday Night Live skit. In the middle of the list statue, which is in downtown Manhattan, someone put this dissent collar around that. Shirts, you can't, you know, that there's RBG workout calendar. And I think we have to ask ourselves, when can we ever remember? When can we ever remember in the development of human history there being a judge or a justice who had a workout calendar devoted to him or her? And I say all of this to really so everyone understands that regardless of who is appointed to the Supreme Court, nobody is ever going to replace RBG because of her societal position as this icon. And throughout the entire debate, part of the reason why the debate as to who is going to fill RBG's seat is so raging is not just because of the polarization of politics, not just because of social media, not just because of the racial tensions and the other things that are happening at this point in time in human history. But the reality is, because she was the first of her kind, because she was like Mike, no one will ever be Michael Jordan. Not even Michael Jordan, the person, will ever be Michael Jordan, frankly. And no one will ever be the notion of RBG. So that's the first lesson here that people should keep in mind, that she really is an icon that transcends herself, and something for all of us to keep in mind. All right, let's talk about the Supreme Court in general. How does the Supreme Court come to be? Whoop, I have to go back. Here we go. The Supreme Court actually has its roots in the United States Constitution, particularly Article 3, Section 1. And it says that the judicial power of the United States shall be vested in one Supreme Court, and then it goes on to talk about inferior courts. And so the other thing that it says is that any justice there shall hold their offices during times of good behavior. A couple things, you know, are interesting to me, not only how they spell the word behavior in the Constitution, but this notion that, you know, while other offices within the United States government and the Constitution were given certain term limits and the like, the Supreme Court justices were not. They were permitted to stay there as long as they acted in good behavior. What type of cases do the federal courts and the Supreme Court hear? This is just a little bit basic stuff. And again, this is in the United States Constitution. They hear constitutional cases. If someone has a question about the Constitution, they hear cases involving laws of the United States, civil and criminal. They hear cases regarding treaties, ambassadors, public ministers, councils. They also hear admiralty and maritime disputes. So something happens on a ship involving the United States, one of the ports or one of our allies, or any disputes over admiralty and maritime. They hear, the Supreme Court hears controversies where the United States is a party. A lot of the cases you'll see so-and-so versus the United States. And they also hear cases in which there are disputes between two states, you know, New York and New Jersey, when they fight, and they often do. One of their cases may go up to the United States Supreme Court, or also if there are disputes between two citizens from two different states. These are the things that the federal courts hear in general. And the reality is that the Supreme Court hears some of these matters on what we call original jurisdiction, meaning cases can go right to the Supreme Court. And they hear some of these cases on an appellate basis, which means first they have to start at the lower court and make their way up. And we'll talk about how that happens. How many justices asked by the National Association of History been on the United States Supreme? Give you some background into how that has worked. So we always the United States Constitution itself does not, if there's going to be a battle as to how many justices should be on the Supreme Court in the future, it will not be, is not rendered in the United States Constitution itself. The only thing, the only justice by name really that the United States Constitution references is actually not even in the judicial clause, but in the section related to the executive branch, and that's Article 1. And it says, when the President of the United States is tried, AKA impeachment, the Chief Justice shall preside. So we know that the Constitution provides that there has to at least be a chief. Okay, so there has to be a chief. How many associates do we have to have, and do we have now? So the first, the way the number of Supreme Court justices gets determined is actually by and via the United States Congress. It is up to the Senate and the House of Representatives how many justices sit on the United States Supreme Court. And so the very first act after the passage of the United States Constitution, the very first act that established how many justices there would be, you can see, and this is the exact language, that the Supreme Court would have a chief and 5 associate justices. So originally that answers the number. How many? When the Supreme Court started, we had 6. The Judiciary Act, a very comprehensive act. That act also, by the way, established the lower courts, what we call the district courts, the Office of the Attorney General, the Office of the United States Attorney Office, and the United States Marshal. So the first Senate and House of Representatives were very busy. Not only did they tell us how many justices we were going to have, but they set up a number of other federal institutions as well. Okay, now we get into politics. And if we think politics are bad now, we're going to have a little bit of history. So here we go. We're going to learn a little bit about the history of politics and the sausage making of the Supreme Court. So let's see, I'm letting somebody into the waiting room while we do this. Okay, so politics. So as you can see, after this first act, I'm going to count here. 1, 2, 3, 4, 5. There have been 6 different acts since then that basically play games up or down with how many justices we've had in the past. So the Judiciary Act of 1801 reduced justices from 6 down to 5. Thomas Jefferson had concerns that the court was getting to be too powerful. Then the Judiciary Act of 1802, right after that, basically undid the act from the year before, put us back to 6 justices. And I have a note, and then the Seventh Circuit Act, which we'll get to in a minute, but there's a note here on the bottom. Marbury versus Madison decided in 1803. So I'm going to tell a story which might sound a little bit like what's happening today. Let's pretend there was a president who was nearing the end of his term. You could call this President Trump, or I don't know, you could call this President John Adams. And then let's pretend that there was an election happening, and whether that was around the year 1800 or around the year now, let's presume there's an election happening. And then let's pretend that there are some judgeships to fill. And you have a new president coming in, and the new president was Thomas Jefferson. And literally the day before John Adams left his office as president, he appointed a whole bunch of new judges. And what happened is he appointed all these judges. He said, you're a judge, you're a judge, you're a judge. And some of them got on the bench, but Adams on his way out the door forgot to sign some of the papers. And so there was one judge in particular, his name was Marbury, and he was promised a judgeship by Adams, who, you know, said you're a judge, didn't sign the paper and left the presidency. And Madison at the time, James Madison, was actually an attorney general of the United States at the time. And so basically what happened is Marbury sued the United States, Madison, saying, I want to be a judge. You have these judiciary acts. I'm supposed to be a judge. The outgoing president said I could be a judge. The incoming president doesn't want me to be a judge. I want to be a judge. And what the Supreme Court basically did in Marbury versus Madison was the first, and law students all over the United States read the case of Marbury versus Madison, and basically what the Supreme Court did at the time was split the baby. The Supreme Court said, Jefferson, you're a bad man, you broke the law. Yes, you absolutely broke the law, but we, the Supreme Court, actually don't have jurisdiction over this issue because we're going to go back to the Constitution, and we, the Supreme Court, can only decide matters that relate specifically to the Constitution. So we're not going to get involved in this little piddly appointment of a judge. The Seventh Circuit Act of 1807 then increased it from 6 to 7 judges. And then you have some activity, the 8th and 9th Circuit Act of 1837, as the United States was expanding and we were expanding westward. We added more courts, more judges, and as a result of that, during this act, they actually increased the number of justices from 7 to 9. And then you have a little debauchery happening around 1863, 1866. And as you can see from my note on the bottom, the Civil War was happening in 1861 to 1865. And again, things are pretty bad today. No disputing, things are pretty bad today, I think, from a political and geopolitical perspective. But we are not in the middle of a civil war, at least not in the traditional sense. So in the middle of the Civil War, you got 1861, 1865, that's happening. You have 2 more judicial acts that come out. One that increases it from 9 to 10 justices. That's pretty good. And then, almost immediately after that, another judicial circuits Congress saying, no, we're going to go down from 10 down to 7, and the way we're going to do this is by way of attrition, and any justice that retires, we're not going to replace. Then in 1869, people came to their senses and says, wait, we got to stop messing around with this. And the Judiciary Act of 1869 was passed by the United States Senate and House of Representatives that basically said, okay, we're going to have 1 chief and 8 associates, 9. 9 is now the magic number. Not since 1869 has the number of Supreme Court justices changed in the United States. So if the lesson in the first part of our talk was that RBG is an icon, the lesson from the second part of our talk is, yes, Congress can monkey around and change how many people are on the court, but it hasn't been done since 1869. So there's talk, Democrats are saying if conservatives placed on the bench, that if they are given power, they're going to pass a law that expands, they may pass a law that expands the court. It hasn't been done since 1869. So a little bit of, politicians are always politicians, I guess. How does someone get nominated to the Supreme Court? Here's a little picture of RBG herself. That actually is in Article 2 of the Constitution. By the way, I have to show you. I just have to. I, as a lawyer, actually keep a pocket version of the Constitution on my person at all times. Anyone who wants to, you can get these. There's lots of places that you can get this. This is from the Cato Institute. You can also get them from the ACLU. So anyone who wants the free Constitution, you should be able to get one for free. Ask me if you need one. So Constitution Article 2, the president shall nominate, and with the advice and consent of the Senate, shall appoint judges to the Supreme Court. So how does this happen? First, you have a vacancy. RBG is gone. Next, the president nominates. The nominee is then screened by the Senate Judiciary Committee, which is a subcommittee of the Senate. They have to interview the person, vote on that person. If and only if the Senate Judiciary Committee says this person should be entitled to a full vote, then they get out of the committee into a full Senate vote. You know, a lot of people pay attention to, so here's another lesson here. Often we pay attention to, oh, who controls a particular governing body? You know, Democrats, Republicans, blah, 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 blah. Equally important to who controls governing bodies is who controls committees, subcommittees, not just parties, but also who their party chair and co-chairs are. Currently, the Republicans hold the Senate, so they you know, also control the Judiciary Subcommittee. If it passes the Judiciary Subcommittee, it then goes to the full Senate. If the full Senate votes yes, and they only have to do that by 51 votes, then the president would sign the commission to have the person sworn in, and there's RBG there being sworn in at the time. I was also asked, this is crazy, Terry, trying to fill justices during an election. Has that ever happened? Well, the answer is not only yes, but heck yes, by 14 different presidents before. There have been 21 justices in the history of the United States that have been appointed to the Supreme Court during election years, including 6 who were appointed as lame ducks, meaning I am the president, I have now lost the election, or I'm retiring, I know a new president is coming in 30 days, but I don't care, I'm appointing my justice anyway. That's been done 6 times in American history, including twice by George Washington. George Washington, our first president, after he gave notice to the nation that he was not going to run for a 3rd term, still, nevertheless, appointed 2 additional justices to the Supreme Court. Very noteworthy, Samuel Chase was nominated by George Washington, and the Senate confirmed him the very next day. Lesson there, things are a little bit slower now. So how does a justice impact, you know, I was asked to describe why are justices important, why do we care who's appointed, and how does it work? So justices are important, first of all, for their opinions, and most people know that, but when we talk about RBG authored no less than 483 opinions. And if you think about that, I don't know that any of us can say we've written 483 of anything in our lives. I may have received 483 parking tickets in my life, but I don't know that I could ever write 483 judicial opinions. And there's 2 kinds of opinions. There's majority opinions and there's dissenting opinions. And majority opinions are important because not only for what they say, but because they actually become the law of the land. We're going to talk about minority opinions, in particular RBG, and why some of her dissenting opinions are also important. But 2 of RBG's most important or most notable decisions, one of them in the majority is the case of United States versus Virginia. And this is, you can see the specific quote from her where she talks about neither the goal of producing citizen soldiers nor, you know, VMI's implementing of methodology is inherently unsuitable for women. So women were really digging that. And I thought it was particularly important, since this is a discussion for the National Association of Social Workers, that we have a duty to know the case of Olmstead v. LC by RGB. This is a case from 1999. And the question was, could people with mental illness and other disabilities, should they be housed only in institutions, or are they permitted? Because whether the prescription of discrimination, as you can see, requires the placement of people with mental disabilities in community settings rather than institutions. And RBG held the answer is a qualified yes. And basically, in writing for the Supreme Court, which became the law of the land, people with mental disabilities are permitted and should be permitted to be living in community settings rather than institutions, based on a number of facts that you consider, including how dangerous they may be, whether they want to, those kinds of things. But it was her decision in Olmstead that really opened the doors. This was 21 years ago. And think of how far people with mental disabilities have come, and how many of them today are now living in less stringent settings and also in community settings. That is thanks to RBG, and the National Association of Social Workers owes her a debt of gratitude. But opinions are important not just for the majority opinions, they're also important for the minority opinions for a couple of reasons. One, sometimes minority opinions, they don't get to be the law. I mean, that's not it at all. But there's two things that minority opinions do, aside from challenging the status quo and saying, you know, you're wrong. The first thing they do is they tell people what they think the law ought to be. It's a chance to say, this is what I think the law ought to be. And the second thing that is very important, I don't know that most lawyers or most non-lawyers know this. When in law school, every lawyer is required to take a whole bunch of classes. One of them is called constitutional law. And in addition to reading majority opinions, I would say it's just about equal reading. Often we are compelled and required to also study dissenting opinions, minority opinions, because they often do foreshadow and raise issues as to what might be coming down the pike. They really do stimulate intellectual conversation. And so a justice's minority decisions or dissenting decisions for some justices are even more important than their majority decisions. And I'm going to give an example of that after we look at two of RBG's decisions. Two cases that she talked about in the minority. One was Bush v. Gore. That's when liberals really started digging her. That involved the recount of votes in Florida. And she wrote, the court's conclusion that a constitutionally adequate recount is impractical is a prophecy. The court's own judgment will not allow to be tested. Basically, you guys are bad and you're making your own thing. By the way, if people have not noticed, on the bottom of this little slide here, that's a picture of Rutgers Law School. I have that there for two reasons. One, because I'm a proud graduate of Rutgers Law School. Number one. Number two, for those that do not know, when RBG was discriminated against, notwithstanding finishing top in her class in law school, notwithstanding being on the Law Journal, notwithstanding all of her qualifications, she could not get a job as a lawyer. And so Rutgers Law School hired her as a professor. And so kudos to Rutgers Law School for seeing how smart she was. And it's part of our great tradition there at Rutgers Law. RBG is a former professor at Rutgers Law. Another decision that a minority decision, and this is something that we would read in law school. It's a woman named Ledbetter who was suing Goodyear Tire, and she basically was alleging that she was discriminated against, and the majority said, you may have suffered discrimination, but we're throwing it out, for time reasons. But even within that minority decision, RBG sets forth what she believes the definition of discrimination is against women, the reduced salaries, the payment of salaries infected by gender-based or race-based, just the language, right? The reduced payment of salaries infected by gender-based or race-based discrimination. So these are the kind of things that, these are the words lawyers hear as we're trained throughout the entire United States. So any justices, minority decisions can be equally important. There's actually one justice whose dissenting opinion I think is his greatest legacy, and I'll give you an example of that. In the case of Plessy versus Ferguson, for those of you that do not know, it was an 1896 case involving Louisiana. Right after the Civil War, Louisiana had a law that they could segregate the train cars. They didn't want brown people near white people on the train cars. And it was interesting because when it went up to the Supreme Court, the people from Louisiana said they were doing this as a favor to brown people because it was safer for brown people to not be around white people. And so what happened is this went up to the United States Supreme Court, and the United States Supreme Court actually held that it is okay, separate but equal is okay, and that will be the law of the land, and it is a good thing. And it was Justice John Marshall here, you can see here, that he basically dissented. And he's like, in the rights, when it comes to civil rights, all citizens are equal. And a very powerful sentence he says here is, the humblest is the peer of the most powerful. This was written, 130 years ago. And so this is a justice whose legacy is embedded more in his dissent than it is in the majority decision. And so any justice on the Supreme Court has tremendous authority and tremendous reach, not just because his or her majority opinions become the law of the land, but also because his or her minority decisions become teaching mechanisms to train the next generation of lawyers. So let's talk about how many cases get up to the Supreme Court per year. There are 40 million cases per year in the United States. That's why I love being a lawyer. I will always have a job. The United States Supreme Court only hears between 70 to 80 cases per year. What are your chances of getting a case to the United States Supreme Court? 1 in 533,000. Well, if that sounds bad to you, it could be worse. You know, it's still better than being struck by lightning, 1 in a million, and a shark bite, 1 in 11.5 million. But the reality is we don't, you know, the cases that get up to the United States Supreme Court tend to be those of great import, impacting millions of citizens' lives. Here's the third reason why a Supreme Court justice is very, very important. Actually, let me go back to this other screen, forgive me. Another reason why justices are important is because given that only 1 in 533,000 cases are heard, a Supreme Court justices, they themselves decide what cases to take. So what happens is if someone has a case and they want to take it up, they have a petition for certiorari, and it takes 4 justices. 4 justices have to say, this is at least a case we want to examine. So another reason why justices are important, not just how they write decisions, but also because there's lots of times where a justice will vote or not vote even to take a case. So, you know, how a justice views the world will determine what cases are even taken up. So a more conservative justice might simply just vote no, not to take something because, you know, he or she doesn't want to touch something. A liberal justice might do the same. So the ability for the Supreme Court itself to decide what cases it hears, that also is why the appointment of justices is important. This is the final reason I believe why justices are important, and this is a picture by Saul Laub. I had to give the thing to Getty Images because I don't want to be sued. This is a very powerful picture. Many of you may have seen this in the news when Ruth Bader Ginsburg, when her body was brought to the Capitol. She was greeted by over 100 former law clerks. Now, let me tell you what a law clerk is. A law clerk is someone who has gone to law school, taken the bar, and before he or she goes to work at a law firm, they go work for a particular justice. Just so everyone is aware, there are 34,000 lawyers who graduate per year across the United States. The chances of getting a Supreme Court clerkship is less than 1 in 1,000. So in order to become a Supreme Court clerk, you either have to be wicked brilliant or super connected, or both. You have to be wicked brilliant, super connected, or both to be part of this army. Now, RBG, each justice at this United States Supreme Court gets 4 law clerks per year, up to 4 law clerks per year. The chief gets 5. RBG spent 27 years on the court, so do the math there, that's about 108. She also spent 13 years on the Court of Appeals. Court of Appeals, you get 2 to 3 law clerks, so that's, you know, approximately 30ish, so that's about 138 clerks. Now I want to share a story with you. I was very fortunate. That I actually enjoyed a clerkship at New Jersey Supreme Court. And New Jersey Supreme Court has 7 justices, and each justice gets 3 law clerks. And I can tell you that while clerking at the New Jersey Supreme Court, at least once a week, the justice for whom we clerked would come out of his chambers, and he'd be holding a piece of paper in hand. He'd say, okay, I got a letter from this big firm, or I got a letter from this agency. Is anybody looking for a job? When you clerk up at a state Supreme Court, and particularly at the United States Supreme Court, large law firms, organizations, governmental agencies come pounding on your door. You basically write your own ticket. You can be a professor, you can manage an organization. These are the people that become the equity partners at the large firms. These are the people that run organizations. And so why it is it's justice's legacy. These 100 people that were connected, and now they are running some organizational law professors. So who gets appointed to the Supreme Court is also very important. It really is an army that then determines how organizations are run, what cases are prosecuted by law firms. It just run the gamut. I cannot understate how important, and this could be her largest legacy. In fact, our own executive director, Jennifer Thompson, started by saying, I was mentored by one of RBG's clerks. So, her RBG's decisions will live on, her clerkships will live on. But the reasons, so just to wrap up, the reasons why justices are important is not just for their decisions, not just the ones they win, but also the ones they lose. It's important because of who, what cases they take in. They're also important because of the legacy they leave of the tutelage that they impress upon the legal profession. So what do we need to do here as social workers, as lawyers, as citizens? First thing we need to do is to show up. We need to show up at conversations like this. We need to show up in all kinds of discussions. We need to show up in our communities. We need to show up at the polls. We need to learn up. So many people, are making statements about, oh, packing the court, not packing the court. It's never happened. Even this whole notion of we're justices, it's not right. We don't appoint justices during an election year. Well, we kind of have. The only difference with the last election was 2016 is that the Senate, put statements out there, oh, we should let the American people decide. It had never been done before. And so if we're going to have conversations, we at least need to understand the history, learn up, so we can be intellectually intelligent about it. And the final thing we need to do is step up. Unless and until we make ourselves uncomfortable, nothing is going to get better. I'll close with my favorite quote from Justice Louis Brandeis, who great line, if we desire respect for the law, we must first make the law respectable. Each of us has a duty to do that. Each of us every day to show up, learn up, and step up. So with that, I think I'll just take questions, Jennifer.
Thank you so much. There's tons of information, and I love the good history lesson of the Supreme Court, so I appreciate that. I think it's so important to take a step back, and the piece that you mentioned about the clerks and what the clerks do and become in their own careers is really important. And I know that it impacts the world in such a significant way, and it's not lost on me that this is the beginning of also Breast Cancer Awareness Month. And Justice Ruth Bader Ginsburg was a mentor to my mentor, and that was Rochelle Shoretz, and she founded the Jewish breast cancer organization Sharsheret. And that is where I worked for Rochelle, and we developed a program for young Jewish breast cancer survivors funded by the Affordable Care Act, which is currently under attack. And so it sort of comes full circle for me, particularly at the start of October. Rochelle passed away several years ago from breast cancer, and we've recently lost Justice Ginsburg. And I think their legacy together is building nonprofit organizations and serving and building places where social workers continue to do good work. So I think as a profession, we've seen the legacy continued on, and it is really an important conversation for us to continue to have. There are tons of questions, so I'm going to jump into them.
Well, I think also, if I may, go ahead, Jennifer. While you're looking at the questions, if I may, I think it also shows the importance of mentorship. I think every one of us has a duty to mentor. And I've been involved with various organizations. I think there's some online now from Wings for Growth. I think a true professional and any justice, his or her impact is going to be not only their decisions, but also their clerkship legacy. So yes, what questions do we have, Jennifer?
Absolutely. So one of the questions that came in, assuming the confirmation of Amy Barrett, what are the implications of a 6-3 conservative Supreme Court, beyond the ACA or Roe v. Wade, any other issues, critical ones that come to mind?
Well, yeah, so I do want to talk about Amy Barrett. First, it is important that we as professionals understand the difference between qualifications and ramifications. There is no doubt in my mind, and I think, again, if we're going to be intellectually honest, that Amy Barrett is intellectually qualified. She went to law school on a full scholarship, graduated first in her class, clerked at the United States Supreme Court. Remember what we said? In order to clerk up there, you have to be wicked brilliant or super connected. And a professor at Notre Dame, 3 times voted by her peers and students as professor. She is qualified. That's different than what the ramification. And I saw another comment someone made. How can you tell if someone is going to be impartial? How can they really take their humanity out of it? And I have 2 answers for you. First, most of the time they can't. Judges are people too. That's one of the things in my book. I talk about how hard it is to be a judge, and just because they put a robe on, the reason why they put a robe on is just because it's supposed to be a symbol of leaving all of their, human emotions and everything, out the door. But so most of the time they can't. That's number one. Number two, but sometimes they surprise you, right? And I think recently, John Roberts, that's a perfect example, appointed by a Republican president, who a couple times has actually ruled against Donald Trump. It's interesting when you look at Amy Barrett, her decisions so far. She is a circuit, she's an appellate judge now. She did have a couple interesting, just to give some insight. People are worried, oh my God, oh my gosh, what does this mean for abortion rights or women's, right to choose? It was interesting. There were a couple things. One, she is known for stare decisis, which means pay attention to what the court has ruled before. But she did write for a majority, Amy Barrett wrote for a majority case involving a communication bubble. There's a law that says that people cannot go within 50 feet of an abortion clinic to try to communicate to women on their way in. And she actually wrote for the majority and upheld that. And so, but she's conservative. Well, but that is something that she upheld. There also was an interesting case, Second Amendment case. The question was, can nonviolent felony people who have committed nonviolent felonies, should they be permitted to have a gun? And so you're like, well, a conservative might hate people that have committed felonies. But, when you have the intersection of the Second Amendment, her position was, she actually wrote a dissent. And when the majority was like, listen, any kind of felon, we don't care if it's mail fraud, we don't care if it's stealing 100 packs of gum, you can't have a gun. And her position was, no, it should only be for violent felons. So I think to answer the question, what will the ramifications be of having another conservative justice added to the court? There's 2 things I would say. One, judges do not put their political ideologies outside most of the time. So most of the time there will be some slants that can be expected. But with that said, there are times where surprises happen, and that often happens when there's an intersection of 2 different rights. So for example, right, the criminality issue plus the right to have guns, or the right to free speech plus abortion. So the surprises tend to happen when there's intersections of 2 diverging issues of law. So I hope that answers the question, Jennifer.
Yeah, I think it does. And I think building upon a little piece of that, a question came in privately just regarding the current nominee, and some conversation about whether she told the Notre Dame class that it's their obligation to their faith to take precedent over their obligation to uphold the law. And if you have heard anything about that, and if so, how can she uphold the law of the land above her own faith?
So that's a very good question. She actually did write an article like that at one point, and I believe she answered, now whether you believe this answer or not, I don't know, but I believe she was asked that question as part of her confirmation to the appellate court, and she said, listen, I was younger then, number one. Number two, I'm bound by stare decisis. And you know what, though? Let me say something at the risk of being politically incorrect here. She wouldn't be the first justice who made decisions based on their faith. There were lots of white justices who decided to keep segregation because the Bible, said slavery was okay. So, the fact that we in 2020 are getting appalled that anyone's religiosity or lack thereof would impact how they rule on the court it's a given truth, right? Judges are human. So we can hope that they're impartial. It's the duty of judicial watch organizations to do so. Frankly, it's the duty of lawyers. That's part of what lawyers do. That's part of why we litigate cases. That's why we make a record of it. It's the duty of organizations to try and hold people to it. But all we can do, and her record as an appellate judge thus far, I've not seen any decision where she says, my faith commands me to do this. And all we can do is hope for it. But if we're worried, oh, she's not going to be impartial, I hate to break it to you, social workers. And look, I love being a social worker. Lawyers think too much and social workers feel too much. So what I'm going to say is, so much time we have these, we think the world should be kumbaya, and we have, everyone's supposed to be impartial. Well, I got news for you. No one's been impartial, throughout the entire history of the court. So really, that's my answer. Sarcasm and all, yes.
I think that's also, it's also something that social workers really grapple with, right? Like the division and separation of your personal beliefs, but the code of ethics, and how do you separate what you might hold to be deeply held truth, but also understanding that your clients and the populations and communities you serve also have the right to their own truths and own beliefs. And how do you honor that and respect it and have individual choice? It's a complicated question.
Yes, it is.
Not unique to just lawyers either.
No, it's not. Correct.
We're human. Another question that has come in, and I'll probably butcher it a little bit, but just if you could speak a little bit to the sort of the timing and the sense of urgency in which the president has made his appointment and the Senate seems to be moving forward with confirming this position. There's certainly guidance that they have a duty and obligation to do so, but is there a duty and obligation to do so with such expediency? Or is there an opportunity really for the Senate to take more time and be thoughtful about this and perhaps wait on the confirmation process until after the elections and after January when the new people are installed?
Well, I think, again, my answer would go back to, George Washington knew he wasn't running again, and he appointed someone in the Senate, confirmed him in one day. So do they have a duty? Duty is such a... duty is a four-letter word, and I say that because, like any four-letter word, it can have variable power and potency depending upon how and when it's interpreted. Do I think that it is prudent for any governing body to take as much time as needed? I do. Do I fault the Senate and the president for doing what they're doing now? If you look at the United States history, frankly, I do not. I think where the true aberration was in 2016. The true aberration was when Obama wanted to make an appointment and the Senate held him up at that time. That really was the aberration. What is happening now, if you look at it from a historical perspective, is not the aberration. That doesn't mean we have to like it. It doesn't mean we have to. And by the way, that doesn't mean that the way it was done before is necessarily right either. Maybe 2016, which was the aberration, maybe that's what should always happen going forward. Maybe it should, from now forward, always be that if there's a Supreme Court vacancy during an election year, that it just shouldn't happen. But then here's a question for you. How do you draw the line of what's an election year? 1/3 of the Senate gets reelected every 2 years. Right, so okay, a president's going to appoint, but we're going to wait. I don't know what the right answer is from a duty and moralistic or even ethical perspective. I can simply tell you historically that 2016 was the aberration, not what's happening now.
A follow-up to that question it really builds on that. The last time this happened, if it was an aberration, does it set any sort of legal precedent for us not being able to move forward now?
It does not set forth any legal precedent. It does set forth political precedent. political precedent can cut both ways. Whenever political precedent is set, politicians pay the price for that, either through glory and victory, right? I mean, because even the fact that this is happening, there are many on the right that are going to be excited by this, and there's many on the left that are going to be excited by this. And the political precedent is probably going to have ramifications for the next, I think, 10 years as to who wins and loses elections. But hello, small person. It doesn't. There's nothing legally that can be done if the Senate intends to do this. So,
yeah. So
unless they, once she's appointed, unless they have another Judiciary Act and decide to expand again through legislative process how many justices are on the court.
Building on that a little bit, I think this is probably the last question we might have time for, although I feel like we could continue this conversation forever. Building off of the 2016 aberration, I'm just curious what your thoughts are on the likelihood that Democrats would try to sort of steal back, quote unquote, if you would, the court by expanding the bench to 11, which restores the equilibrium.
So what are the chances of that? I don't know. They, in order to do it, what they would have to do is expand, they'd have to expand the court to at least 11 justices. I don't see them expanding it to 10, because if you expand it to 10, you could have a 5-5 tie, and we don't like ties. We need there to be an odd number of justices. So they do have the authority to do that. Interesting, if the Democrats win the Senate, but they lose the presidency, and Donald Trump is still president, then they won't have the ability to do that, because Congress may pass the law, the House of Representatives and Senate may pass the law to expand the court, but if Trump is still in power, he has to sign it. So first of all, the only way a law like that is going to get through is if Democrats have the House and the Senate, and they have a sitting Democratic president who's willing to sign it. So how likely is that? Do they have the stomach for that? Maybe they do, and although it's been since 1860, hasn't been since 1869, since the judge, the judges were packed, so to speak. So many other norms have been shattered during the last 5 years, and even 10 years in human history, for various reasons that it wouldn't surprise me if it happened. But in order for it to happen, there needs to, Democrats need to win the House, the Senate, and the presidency, and a bill has to be put forth, passed by both the House and the Senate, and then signed by the president.
That is a lot to be done. Well, I appreciate these thoughts. As we sort of near to the end of our conversation, they fly by. I'm just curious if you have any sort of last thoughts and words of advice. How can people just become more involved in this process? And is there anything that we can be doing right now to ensure that the Senate goes through with this confirmation process in a thoughtful way, not rushing it? What can we do today?
So first thing you can do is contact whoever your senators are. And I would say particularly those people who are represented by Republican senators, let them know that you would like them to be thoughtful. Democrats are already resigned themselves to being thoughtful, not because Democrats are necessarily more thoughtful than Republicans, but when you're in the minority of any political party, you always are the ones that are thoughtful, because you can't act. You might as well sit around and think. Reach out to your senator, let him or her know why it's important for he or she to be thoughtful. Speak up when you see people saying ignorant things. I think we all have a duty to say things, to challenge ignorance, wherever that may be, even if we don't like what the truth is. I think we all have a duty to speak the truth, even when we don't like what the truth is. And so those are things I believe that we can do in our daily life, and keep an open mind and try and be understanding.
Yeah, I think that's really important. Certainly keeping an open mind, but being thoughtful and just being aware of what the process is and what it can mean for you personally, but also understanding what it means for the communities. And I think when things like this happen, the loss is felt and people can often realize also just generally what we don't know about the process and what we don't know about the court. And I think these are really good learning opportunities for us to understand how the Supreme Court touches our daily lives in ways that we may not have always recognized. Well, I appreciate you sharing with us today and leading this important conversation. I think it's a perfect way for us to honor the legacy of the justice and the work that she did, not only on the court, but to mentor just hundreds of people who have created organizations, worked in law firms, built businesses, and impacted our communities on here in New Jersey. And, you know, she did work at Rutgers, and so I guess we can claim the justice is ours here in New Jersey as well. Thank you so much, Terry. I appreciate your time with us, and for everyone here for joining us. This is part of our road to November. We really want the community to be educated about what's at stake in this election and the process in general, and we hope that you'll continue to join us for these important conversations. We are having them weekly, a variety of community conversations, and you can catch up on all of the past ones, but learn about the upcoming ones on NASW-NJ.org. And we look forward to more continued conversations with you, Terry. Thank you so much for joining us.
Great, and thank you, everybody.
Thanks.